Ballard, how many cases have you had overturned in the appellate court based on inefficiency?
Based upon inefficiency?
Inefficient, that's the wording on the card.
I'm going to say none. I mean, I don't understand the question. I haven't kept count of the number of cases that have been overturned on appeal. The number of cases you have overturned on appeal is really not a barometer of the prosecutor's office. I've seen where my opponent has said that during my time as the DA, we've had 6 cases overturned on appeal, and I took a look at those. One of them was a case where the person had 22 charges, was convicted of all of them, and 21 of those charges were upheld on appeal. One of them was reversed. One of the cases was a case that had been prosecuted before I became DA, and we just handled the appeal but didn't have any control over what happened at the trial. One of the cases was overturned on appeal because the Court of Appeals found that there was insufficient evidence to convict, which really just means that the prosecutor was able to get a conviction with too little evidence in the eyes of the Court of Appeals. I just don't think it's a good barometer of how successful you are as a prosecutor.
I believe that it is one of the good indicators, as to use Mr. Ballard's word, a barometer of how well you're doing. I mean, one, if you're getting a conviction and it's insufficient evidence, it's a case you shouldn't have tried in the first place. Okay? That's one of the things that prosecutors got to do is weed out cases up front and determine whether or not there is sufficient evidence to go forward. If there's not sufficient evidence, you shouldn't be trying it. And then cases on appeal, you know, let me say this. I have never been reversed or overturned on appeal. I'm very proud of that because I do my work up front. I understand the law, I understand the facts in the case, and I apply that. But when we've got cases that are being overturned because they're indicted incorrectly, I think that is a huge barometer of what's happening in the DA's office. And that's the exact issue with Self v. State.
Another question from the audience. With the jails inundated with white African American people, what do you think is the cause, and what can you do to help moderate this problem?
The only reason I know of that people are in jail is because they've broken the law and they've been arrested and they're in jail. That's the cause.
Excuse me, let me follow up with Scott on that. Scott, you're telling me you're not aware of injustices where people have been falsely accused and in jail. And I think that's the intent of the question, because a lot of times, quite frankly, a lot of times you are prosecuted based on things other than the facts and circumstances of a case. And you certainly should be aware of situations like that.
The people are not in jail because they're African Americans. They're in jail because they've been accused of crime. And while it may be that some of them will ultimately be acquitted, some of them may actually be innocent of it, it is not because they're African American. It's because somebody found that there was probable cause to believe they committed a crime.
Mr. Hayes.
You know, I agree that most people, I mean, people are arrested because there's an allegation of a crime. And the thing that's important here is we have a multi-tiered system. You know, there's preliminary hearings, there's bond hearings, there's accusations that need to be reviewed, there's a grand jury process. All of those things have to be taken very, very seriously, and the district attorney and assistant district attorneys have got to be involved in every step of the process to ensure that the proper person is charged with a crime. I think that's paramount. That's one of the responsibilities that the district attorney has, is to seek justice. Obviously, the first and foremost is uphold the law. Secondly is take care of the victim and the public. But one of the other things that the DA's office is couched with protecting are the rights of individuals going to trial. And we have to be more aggressive with weeding out cases and looking at the facts early on so that no individual, black, white, male, female, Hispanic, Asian, anybody sits in jail for a long period of time without having that case properly reviewed.
Thank you.
Attorney Ballard, this is directed to you. Your slogan says, guard what's ours. Does that include people of other races?
Absolutely.
Does that include people who are not from Fayetteville or Fayette County?
It includes anybody who is a citizen of the Griffin Judicial Circuit whose property or whose person or whose family has been threatened by criminals. It includes our communities in the Griffin Judicial Circuit. The objective of any law enforcement and ultimately the prosecution's office is to protect the public and to guard what's ours. I think that's the crux of the matter. The absolute truth of the matter is, in Fayette County, most of our crime comes from outside of Fayette County. So to that extent, it's directed toward those, anybody, whether they're citizens of our community or from outside the community, who would come and commit crimes against our citizens. We're guarding what's ours.
Okay, Scott, here's a hot one for you. How do you reconcile sending a young man to jail for 4 years and testifying on behalf of a convicted child molester by saying the convict is worth taking a chance on? Was a young African-American male not worth taking a chance on?
Well, I think they're two totally different situations. I'll tell you, with regard to the young man who that you're making reference to, I'm assuming you're talking about the recruiter for the Bloods that was in Fayette County High School trying to recruit gang members here. And I think it was very appropriate what the sentence that the judge gave him to go to jail for 4 years. With regard to the person who I testified on behalf of down in South Georgia, let me just tell you what happened. A lot of people still aren't going to like it. I understood when I decided this that it was a controversial thing to do, but I did what I thought at the time was right. I lead a prayer group at my church. This man was a member of the prayer group. 18 years earlier, he had been placed on probation in South Georgia for child molestation. He got drunk. He got he didn't pay his taxi fare. He scuffled with police officers, and they sought to revoke his probation in South Georgia. I was served with a subpoena. In my business, we rely on subpoenas or we can't operate. I honored the subpoena as a courtesy to the court, and as a courtesy to the court, I went down there and I told the judge information that I thought he needed to know to make an important decision, and that was that this person probably needed alcohol treatment, that if he didn't get it, he might be a threat to other people.